Hi, my name is Patty Cush. I'm a senior attorney in the Atlanta region of the Federal Labor Relations Authority. Today I'm going to be talking to you about information requests under the statute. Section 7114B4 is the part of the statute that sets forth an agency's obligation to provide information to the union. That section lists certain requirements that must be met in order to find that the union is entitled to the requested information. The information must be normally maintained by the agency in the regular course of business, reasonably available, and necessary for full and proper discussion, understanding, and negotiation of subjects within the scope of collective bargaining, and does not constitute guidance, advice, counsel, or training provided for management officials or supervisors related to bargaining. In the next slide, we will discuss each of these requirements in more detail. The information the union is requesting must be maintained by the agency in the normal course of business. However, this doesn't mean that the information must be physically located in an agency building. The information must simply be within the agency's control. So, for example, if the agency has a contractor for personnel matters, then personnel information would be within the agency's control. The information the union is requesting must also be reasonably available. Here we're looking at how much time it would take and how expensive it would be to compile the information. When looking at time and expense, we'll look at each request on a case-by-case basis to see whether it's reasonably available. Something that may be cost prohibitive to a small agency, for example, may not be for a larger agency. Also, be aware that the authority has found information to be reasonably available even when it would take many hours and hundreds of dollars to compile. So the cases we review usually don't come down to this requirement. Also, now that many documents are kept electronically, that's going to impact whether information is considered reasonably available. So that's another thing to keep in mind. We're going to talk about this Hypo, Information Hypo 1. A human resources officer receives an information request from the union. It looks like the union has shown the information is necessary, but fulfilling the request would require the HRO to go through thousands of pages of documents, would take several weeks to put together, and would cost $3,000. How might the agency respond to this request? The agency's response to this request could be that the information is not reasonably available. Perhaps the agency could get the union to narrow the scope of the request. Keep in mind that the authority has found information was reasonably available even when fulfilling the request costs time and money. Information Hypo 2. The union believes that a particular supervisor is discriminating against an employee on the basis of religion in regard to leave requests. The union submits an information request asking the agency to provide information about which religions employees in the supervisor's group ascribe to. What might be the agency's response to this request? The agency could tell the union that this information isn't normally maintained within the meaning of the statute, because that isn't something that would normally be in their records that they keep of their employees. The union must also show that the information it's seeking is necessary within the meaning of the statute. This is what most of the information request cases the OGC reviews comes down to, whether the information is necessary. The authority has developed a test to determine whether information is necessary, which I will discuss momentarily. The information the union is requesting must be needed to fulfill the union's representational responsibilities under the statute. This includes filing a grievance, negotiating and administering the collective bargaining agreement. If the union wants the information to represent an employee before the MSPB or EEOC, that would not meet the necessary requirement because the union is not obligated under the Federal Service Labor Management Relations Statute to represent employees in those proceedings. However, the union can obtain information for those proceedings through the MSPB and EEOC procedures, just like anyone else could. The union can also obtain information to support a grievance, even if it's a matter that could have been brought to MSPB or EEOC. The union can also obtain information through the statute if it's still deciding between filing a grievance or going the EEOC MSPB route. The test the authority has developed to determine whether the requested information is necessary is the particularized needs standard. That standard is written on this slide. It's the wording from the IRS case that you see cited at the bottom, but the next slide is probably a better slide to come back to and reference if you're trying to meet the standard as the union, or if you are an agency evaluating whether the standard has been met. To demonstrate a particularized need for the information, the union must state why it needs the data, how it will use the data, how the data's use relates to the union's representational responsibilities under the statute. For example, if the union wants to represent an employee in a disciplinary matter, it may request the entire investigative file that led to the disciplinary action. The union would want to explain that it needs the investigative file to determine whether there is any exculpatory evidence that should have been considered in issuing the disciplinary action. The union would further explain that it was going to use the information to determine whether or not to file a grievance, which is part of the union's representational responsibilities under the statute. The union can't merely say that the information is needed to represent an employee or file a grievance. The union should be as specific as possible about its need for the information, although the union doesn't have to give away sensitive information about the employee that isn't needed to evaluate the request, and the union isn't required to give away its entire litigation strategy. The explanation just has to be enough to allow the agency to make a reasoned judgment about whether the data must be disclosed. When a union is drafting an information request, it should think about the scope of its request, and the agency can ask the union to narrow the request if it's overly broad. So think about what type of data is needed. Does the union need all records of suspensions or just suspensions for lack of candor, for example? Does the union need suspension records from the past 5 years to obtain enough of a comparison to the employee it is representing? Or would 1 year be enough? That's going to make matter on how many of the disciplinary actions are normally issued for that type of disciplinary situation. And does the union need all suspension records from the entire agency, or is this issue confined to just one department? So those are all types of things that you would want to ask yourself when drafting a request or when responding to a request, to see whether the request is narrow enough. Information Hypo 3. A union asks the agency for information related to performance awards, asserting as its particularized need that it needs the information in order to file a grievance on behalf of an employee, which is part of the union's obligation to represent employees. Has the union met the particularized need standard? The union has probably not met the particularized need standard. It has stated what it plans to do with the information and how that relates to its representational responsibilities, but it hasn't stated why it needs that particular information. Information Hypo 4. A labor relations officer receives an information request from the union. It's clear, based on authority case law, that the union hasn't shown the information is necessary. The labor relations officer throws the request in the trash since it would be a waste of time to respond. Has the agency violated the statute in this case? The agency has probably violated the statute because the statute requires the agency to respond to the request, even if the union has not shown the information is necessary. When an agency gets an information request, it must respond in some way, even if the union is not entitled to the information. The agency must tell the union if the information doesn't exist or explain any interest it has in not providing the information, which is referred to as a countervailing non-disclosure interest. For example, if a union asks for the location of all surveillance cameras, the agency may assert a security interest in not providing that information. However, the agency must raise this concern at the time the request is made. Raising that at hearing is too late. If the agency does assert a countervailing anti-disclosure interest, it must be weighed against the union's interest in obtaining the information. If the agency asks the union to clarify its request, the union has to do so or risk a later filed ULP charge being dismissed if we find the request was reasonable. The authority intended for the information request process to be a dialogue, so the parties really should communicate as much as possible about the request and have meaningful conversations about it. In regard to the parties' communications, the next 2 slides contain observations from ALJs who are reviewing information request cases. They illustrate the importance of actual communication between the parties. In this first one, the ALJ noted that the agency's response was conclusory boilerplate that demonstrates a fundamental failure to comply with the requirements of IRS. Reply was little more than a laundry list of potential justifications for non-disclosure that might apply to any case, with no application to the facts presented by the particular request. Reply was internally inconsistent, and it represents the mindless stonewalling IRS is intended to eliminate. And in this case, the ALJ commented on the union's request, stating that the union's request was a very long document containing a considerable amount of generalized, legalistic language that challenged the reader before he or she even learns what is actually being sought. It resembled a discovery request drafted by a lawyer for civil court litigation. Judge expressed a personal note of dismay that the everyday process of information gathering has become so formalized and encrusted with boilerplate. He concluded that these requests tax everyone's energy and goodwill, and that while unions have a significant burden in articulating the need for information, the key is the quality and not the quantity of their request. So those are important things to keep in mind. I know that when we review cases, we often see people using boilerplate language from our case law instead of having an actual conversation about the request at hand. Sometimes the union is requesting personally identifying information. If the union wants employees' names, for example, the union must establish a separate particularized need for personal identifiers, and when information without identifiers is better than nothing, the union should request the information with and without identifiers, or risk getting no information at all. When the union is requesting information that violates the Privacy Act, the union can request that the documents be sanitized or redacted to address those concerns. The Privacy Act applies if the data is maintained in a system of records, disclosure of data would implicate employee privacy interest, and employee's privacy interest is significant. The union has a couple of options if the agency has raised a Privacy Act defense to not disclosing the information. The union may show that the information is covered by a routine use under the Privacy Act, or identify a public interest in the information within the meaning of the Freedom of Information Act, and explain how that public interest will be served by disclosure. The only public interest the authority will consider is the extent to which the disclosure would shed light on the agency's performance of its statutory duties, or otherwise inform citizens about what the government is doing. The union's interest in representing the employee is insufficient because that is considered an institutional interest. The public interest in collective bargaining is also not considered. The authority will use a balancing test to determine whether disclosure is warranted, balancing the public interest against the individual privacy interest, but it's a hard test for the union to meet. That's why so many times we see that sanitized information is requested instead. That concludes our presentation. If you want to learn more, you can attend our trainings in person. Our training schedule is on our website at www.flra.gov, and it's under the Resources and Training tab. You can also schedule your own training. You can contact the regional office nearest you if you have any questions or you would like to arrange in-person training. We would appreciate it if you would complete a survey on how you like this training module. That way we can see if we should develop more in the future. There is a Take a Survey button at the end of this presentation, and we encourage you to use that to give us your feedback. Thank you so much.